And as always, reviews and comments are welcome on the show. Look for us on our social media handles at Joy News on TV on Facebook and on Twitter. We'll be glad to share your thoughts with the rest of the world. Now, it was a day eagerly anticipated, especially by the business mogul and the presidential hopeful, but the legal showdown built up a lot of public interest. Well, the news now is simple. And Accra High Court has directed the Electoral Commission to allow the Progressive People's Party's presidential nominee correct the mistake on his forms. And as you can imagine, the celebration for many supporters of the party have had the loudest voice in the country, with the court complex inundated with thousands of followers in a sea of red and white. The scene. This will mean Dr. Papakwesi Nduom will most likely be on the ballot paper come December 7. We'll look into the details and the implications for you here in just a moment. But let's bring you an interview that Dr. Nduom granted today after the proceedings of what has happened.
This is not anything that in any stretch of the imagination I would have imagined would have happened. I also want people to know that as we went through this process, I am a Christian, I'm a Catholic. I wrote to the Catholic bishops to pray for me, to help me to understand what has been going on, and to pray to God to give me some strength and some peace of mind to go through this process. So I thank God for going through all of this. There are also thousands and thousands and thousands of people who have been sending messages that they have been praying for me, they have been thinking about me. I thank them very much. I thank my family for standing by me through all of this, and the supporters, friends, PPP members, well-wishers. I thank everybody for where we are today. But it's important that I make the point, as I have been making from the very beginning, that institutions of the state, people whom our taxpayers' money provide the support and their living, and for the money for them to run their affairs. It is important for those people who have been set up because the Constitution says they must be there, and who are there because Parliament has given them the procedures that they must use. It is important for those people to believe and understand that they are human beings. They are not there for their own purpose. They are there to carry out the dictates of the laws that set them up. And that when we talk about strong institutions are built by following the law, for respecting the rights of everybody, and making sure that they work for the people, not that the people work for them.
So that's Dr. Nduom today sharing his thoughts after proceedings. We'll get to the details in the courtroom in just a moment, but still staying out there where Dr. Nduom addressed journalists today, the supporters of the party, as you can imagine, have been loud in their voices and also their presence felt at the court complex. Some of them spoke to Joy News.
The leaders we had for the past were not telling us the truth until I met Mr. Papakwesi Nduom, doctor, before I decided that I want to come into politics because of doctor. But as things were going, there were no truth in Ghana. So we need somebody who has to change some things in their constitution, some of their constitutions. So as I heard what doctor wanted to do, then I said I have to devote all my time, my everything to doctor.
For all of us, even the way we are deliberating here, look at the population now. It lets all of us change our mind that it's really true that the court have denied our truth for us, and it's God. So our prayers have come in today. If somebody said our prayers have not come in, then the person is not a really Ghanaian. And I can see that our prayers, God have answered to us. That's why we are all happy here. And so we don't know how to do, but we pray that it should come. When it comes, we know those who are suffering. For about 2 years now, my job has spoiled. Because of that, my wife and my children are being at village, and even my village self, they are suffering there. So once we change our mind and see the changes and see what will happen.
And as you can imagine, the celebrations were quite thick at the court complex. You saw someone's face pop in the screen, didn't you? Well, that's Joseph Akable. He was our man in court. He joins me now. Joseph, been a while. I know you're tired, aren't you?
It's been a stressful one, I mean, but at least one case is done. There are some more cases to come up in the next week. On Monday, we have that of the APC. Also on Tuesday, that of the PNC coming up.
Was that intentional?
I wouldn't say so.
Okay, now let's get into the details of what you covered today. We know that there's a lot of celebration, but let's come down to the basics. What happened in the courtroom? What was the atmosphere before the ruling, and then you take us to the ruling?
Now, even before I got into the courtroom, I must say it was very difficult to get in. The reason being that the judge had given a directive to the court officials to allow a limited number of people get into the courtroom because it's one matter that he knows will attract the attention. Then again, the supporters were not allowed in, so only the party executives, the flag bearer, the running mate, his family were allowed into the courtroom, as well as journalists. So that was the first difficulty. The supporters, they stood outside the court complex, they waited patiently, anxiously. When we were in the courtroom, there were moments where you could hear them sing and dance, especially getting towards the latter bit of the ruling. So that was the situation in terms of the outside the court issues.
Okay, now with the ruling proper, what were the details of that ruling as given by the presiding judge?
Now you recall when they made their oral arguments at the very initial stages, the EC's lawyer Thaddeus raised some initial objections. So the judge first dealt with those objections before he moved on to the substantive issue to give a ruling. Now those objections, the first and foremost was that the PPP should have come by a petition and not a judicial review. That was the view of lawyer but on that score the judge disagreed. And the judge's point that he made is that the courts have supervisory role, and when it comes to issues of human rights, people feel that their human rights have been trampled upon, the court can make a ruling on that. So it's in line with that point that the judge decided to dismiss that particular objection raised by lawyer Another objection that he raised was the fact that the court cannot compel the EC, the court cannot order the EC, and his point that he kept reiterating is the fact that if the court orders the EC, what it would mean is that the EC is no longer an independent body like the Constitution says the EC is. But then again, on that ruling, the judge made a point that that particular view is pedestrian. The judge made a point that ruling is pedestrian, and in the sense that he says just yesterday the Supreme Court ordered the Electoral Commission to make available coalition sheets to political parties and agents. So why then do you say that the EC is independent and we cannot order you? So on that score too, he again disagreed, and he even added again that, I mean, such a view is bereft of substance. And those were some of the interesting bites from the judge in the courtroom. Then he moved on to deal with the substantive suit. And with that one, the main arguments that were put forward by lawyers for Dr. Nduom was the fact that Dr. Nduom was not given an opportunity to correct the mistake when the EC realized that mistake, and talking about the CI 94 allowing for that. Then again, lawyer Ikotu again argued that the EC, per the laws and as well as the communique from the EC didn't fix a nomination period as the EC was supposed to fix. And he added again that the EC only fixed a nomination day. And on that day, which was 2 days actually, and on the second day, they presented a form. So they expected to hear from the EC within that day, but unfortunately, they didn't hear from the EC. The EC's lawyer, Thaddeus, disagreed, and he said, we gave him hearing, referring to the 5 minutes that Dr. Nduom had with the EC chair after his disqualification. He makes the point that if Dr. Nduom had brought the forms earlier, that would have enabled him enjoy that right that CI 94 allows him to enjoy. But in all these issues, the judge again disagreed. The judge points out that the law is very clear. You should give him the opportunity. You didn't give him the opportunity. The judge again says the EC didn't fix a nomination period, and he read the EC's release to the parties, asking them to present it on 29th and 30th. And he makes the point that it was on those 2 days that you asked them to present. So he's clear in his mind that no nomination period was fixed, and nomination day was fixed. They brought it on that day, and you should have given them the opportunity to correct any mistake.
Now, when the judge read this ruling, what was the first reaction of the Electoral Commission?
Lawyer Sorry was very calm. And the interesting thing is that the judge started by dealing with the initial objection. So with those ones, he didn't go in favor of Lawyer Sorry. So the look on his face in court, he wasn't happy. EC Deputy Chairperson Amadou Sile was also in court. They were not happy at that point. You could read from their body language. They were clearly not happy. Then the judge moved and said that before I deal with the main issue as to whether he was given a chance or not, there's another issue that I quote you raised, and he says the document they presented to the EC, on the face of the document, when you see it, you realize that it's an error. On that score, the judge disagreed with them, because the judge says if Francis Aban, for instance, signs at one point and you see it, you will not know that it's a mistake until you realize, you open another page and realize that there's another Francis Aban who has signed there. So on that score of error on the face of the document, he disagrees with them. So at that point, it appears the EC has lost 3, Dr. Nduom has also lost 1. So at that point, it appears it is shifting. Then everyone gets anxious. The EC lawyer begins to smile a bit, getting comfortable. Dr. Nduom's lawyer, not so happy. But then the judge goes on to state clearly that, the main issue, you made a mistake, you didn't give him the chance. At that point, lawyer Ayuko begins to stretch. He's trying to take a look at Lawyer Sorry at his other side. And he's telling the other counsel that they should alert him to have a look at him. While the judge is still reading the ruling, he was still trying to catch his attention. And once in a while, you hear him be like, I told you. So
that was Ayuko too?
Yeah, Ayuko.
Okay. So when the ruling proper, the main issue, the substantive matter was read, what were the reactions then?
And one thing I must also mention, that Dr. Nduom came in wearing white, so it was clear that, in our traditional sense, when people wear white, it signals victory. They expect some good news to come their way.
But again, to be fair to him, his party's colors are red and white. So
exactly,
if he's in those
exactly.
colors,
but the last time he came to court, he was in a black suit.
He was in suits with his colors, his party colors, isn't it?
Yeah.
Okay. So after the ruling was read, I know that there were some other key individuals who made it today to the program. You've already mentioned Nduom, as we can see on the screens right now. The wife made it with him to the courtroom. The sons as well made it there. Did they have anything to say after the ruling? They
were just allowed their father to do the talking. But you could see the look on their face, and it's very important. I can understand for Dr. Pakwesi Nduom, because it means it's something that was very important, a decision not just for himself but for the entire family. Because the first year when he came alone, but this time around it's a judgment, and you can imagine why he would choose to come with his wife and 2 children. If it doesn't go your way, you have your close family to console you. If it goes your way, you have them close to you to celebrate.
Okay, that's Joseph's interpretation to this, but it's fine. Well, the star man in all of this, in this case, as we learned from Tuesday, is the lawyer for the PPP, Joseph Ni Ayikwe-Otu. What did he have to say for himself on today's case?
Even before he spoke to the press, right in court when a judgment was delivered, he made a request for some cost to be awarded, and he made reference to the fact that just yesterday the court had awarded the EC a cost of 10,000, that is coming from the NDP. So he requested for cost to be awarded him, and he requested for 20,000 cedis. But then the EC lawyer Thaddeus rose up and said that, oh, you brought a matter to court, you asked for relief, you have won the case, that should be the end. Why do you need the money again? Then Ayuko stands up again and he makes the point that, okay, this was a battle between father and son, so I can pardon you, let the money go away.
Interesting. But for him, after proceedings today, what did he have to say about the details? Because he did indicate on Tuesday that if this ruling does not go in his favor, they may proceed to the Supreme Court. So now they've got what they want. What was his reaction?
The sense you get from him is that he is very convinced that this ruling is important for our democracy, and he makes the point that the rule of law has been stated and established in clear terms.
Let's have it now.
It only reinforces Article 23. Article 23 is clear that administrative bodies and administrative officials are under a duty to live by the laws that set them up. And any person who is aggrieved by any such decision can come to court. The right is already given to them in the law itself, Article 23. It's so clear. And you'll find that the law set, dealing with elections ACI 91, which is the Public Elections Regulations. And it provides clearly that when the documents are brought and you find any anomaly, give the person the opportunity to go and effect amendments and alterations. This was not done. So his rights, to be heard was not given to him. And again, you find that the EC did not live in accordance with the law setting it up and went contrary to Article 23. They cannot say that it's a law unto itself, because Article 46, which gives it the opportunity, grants it that right to be an independent body, even states that it is subject to the Constitution itself. You understand? So it is victory for democracy. I think people should take Article 23 of our Constitution very, very seriously, because there's a right given to everybody. You don't need to be a judge. This used to be the old position of the law, that Sasorara will go only for judicial and quasi-judicial activities. No way. Now what the law is saying is that once you are satisfied that a decision has been taken which was not fair to you, a decision has been taken by an administrative person which was not in accordance with the law, you should just come to court.
Right, so that's Ni Ayikwe to Joseph Ni Ayikwe to the man who represented the Progressive People's Party in court today. Joseph, anything else we missed we have to talk about?
One thing that we need to understand is that with a court order, it's just an opportunity for Dr. Nduom to correct the mistake. So we expect the Electoral Commission, in fact, we are expecting to hear from them to Dr. Nduom, to ask Dr. Nduom to come over and correct the mistake. And once that is done, if they decide to accept his form, then we'll be back on the ballot.
Thank you, Joseph, for those details. Now, after the short break, we'll begin the analysis of what this ruling means, especially for the electoral process, because we know that some others were disqualified. Is this the means for them to also begin to pursue their options to see if they can get their names also on the ballot paper? Details after the break. Stay with us. You're welcome back to the Pulse on the Joy News channel on Multi TV. Just before the break, we're looking at the details of that ruling given by the High Court today on that matter of the disqualification of Dr. Nduom. Well, as we know now, he has the opportunity to correct his mistakes on his nomination forms as per the ruling of the High Court today. Let's interrogate this matter a bit more. Yao Pong is a law lecturer who will share his thoughts with us and his perspective on today's ruling. Thank you, sir, for joining us today.
All right, thank you.
So first of all, I want to find out what you make of this ruling from where you sit as a legal practitioner and with some experience in law lecturing.
Well, justice has been said.
Sorry, when you say justice has been said, what does that mean?
Well, justice has been said, the law has been applied, and everybody has got justice. I think it's the rule of law that has won.
Okay. Now, some have interpreted this to mean that it's a straightforward case that Dr. Nduom is in the gunning for the elections. Is that what it is?
Well, I sat in the courtroom, and I've had the benefit of assessing the ruling. I do not think that the decision had anything to do with whether or not there has been commission of an error by the applicant or their agent. The court only looked at whether or not the EC followed due process, applied the rules of natural justice, gave them the opportunity to be heard, or gave them adequate opportunity to be heard. And that is what the court found out, that they may have breached, or the EC did breach the rules of natural justice. And so the court have asked the applicants to go back to the EC, or that the EC should afford them an opportunity to be heard and to decide to consider whether or not they have complied with the mandatory provisions of CI 94. That's how I understand it.
So, if I'm hearing you correctly, you're saying this is not an automatic qualification for Dr. Nduom to contest in this year's election.
But the law has never stated that once a person applies to the EC, the person automatically then have his name, will automatically have his name on the register or on the ballot and be voted for. The law states clearly that the person stands nominated unless, and then it lists the instances where that position can be varied. And so it is up to the applicant to go back to the EC within a period stipulated by the EC, and the court made that clear. And in my view, if the EC believes that they have not been able to comply with the law, then they still reserve the right to either accept or reject it. In my view, the mere fact that you are giving a fair opportunity to be heard doesn't mean that the other person's right also or entitlement to also examine you or what you have brought before them and to take a decision has therefore been taken away from them. That is not how I understand it. So I don't think it's an automatic thing. First of all, we have to still contend with the issue of whether or not what occurred constitutes a mistake, as I heard someone just say on your network. In any case, the law is concerned with or about errors. And what kind of errors will also be a matter maybe for further determination, because it's not, in my view, everything that the EC can correct or can cause to be amended or altered. In any case, the court found that there was no error on the face of any of the documents. So that may, if people still want to test some other incidental or collateral issues, they still form a different basis of course of action. But I believe that it's about time maybe people may want to move on so we can just have our elections and move on with our lives.
It's interesting what you say, because per what we were made to understand and per what our court reporter told us, the ruling of the court was for Dr. Nduom to go back to the commission. Any anomalies on his forms, he will be allowed that opportunity to correct. You're saying per what you heard, that's not what it is?
Get a copy of the judgment and read it. It's in plain English. I'm saying that is why the court said that one, they should set, the fact is that according to the court, there was no nomination period fixed by the East, so they should do so for this particular applicant. And then also correct the errors and consider whether they have complied with the law. The correction of whatever errors, whether they are errors, they are also subject to a determination. What constitutes an error is also a different kind of determination. And I think the EC is still reserved or is still entitled by law to consider whether or not, in the case of these applicants and others, what the issue really is about is an error or something else that cannot be corrected or amended or altered. That's the point I'm making.
Okay, so for those who may think, and we've already heard some of the comments being made by some lawyers, that in view of this ruling today, all the other disqualified aspirants can, as it were, withdraw their contestation in court and file a new one based on this precedent to get a chance of also getting their mistakes corrected. Is that a possibility?
Oh, well, I mean, you don't apply a decision of a court wholesale. That is why we say that even when a court is bound by precedent, for example, a decision of the Supreme Court, you still have to look at the facts before you and not merely the judgment. The facts before you, are they the same or similar to the other facts based on which a particular decision was given? Then that will even amount to saying that they don't have to go to court at all. They just go to the EC and say that one court has decided, so that is it. But I think if I were the EC, I would just throw it at all the parties that, well, based on this judgment, and this is my suggestion, based on this judgment, I think we should all come over, and if you all meet the criteria, we have all 17 on the ballot, and we move on.
So if that does not happen, per the suggestion you just made, what do you think may happen? You're thinking that this could open up another Pandora's box for several lawsuits?
Well, I think that is also an option, whether the EC will still insist that they still reserve the right under law to determine whether what the impugned situation constitutes an error that the EC or the parties can alter or amend as the law puts it. Or it's a kind of, if you like, an anomaly or an error that goes to the root, maybe relates to commission of an offense, and no one should be seen to condone commission of an offense and all that. Those determinations are yet to be made, but it depends on whether people will continue to insist on the strict application of the law.
Okay, so Mr. Prong, just to conclude, there was one leg of this ruling that I want us to look at briefly. You recall that when the Electoral Commission came out with this release on the PPP's candidates and why they had disqualified him, there was an element of one person subscribing for two in two different districts. They point to a matter of forgery as a criminal matter that should be investigated. What then becomes of that leg of the reasons for his disqualification?
Well, that was not the case before the court. In fact, the court made it clear. And I so believe that most lawyers will agree, or most persons will agree, that certiorari is not concerned with the substance of the case. It is not concerned with whether a person has committed an offense or not. It is just to look at the procedure. My only worry is that there are other authorities that once the issue of an infraction of a law or the commission of an offense comes before a court, it doesn't matter how that matter came before a court. The court of law has to look at it. But in this case, that issue was not even part of the issues that were placed before the court. And it couldn't have been, because the lawyers, well, the parties who took the matter to court were only concerned about whether or not procedural rules, which go to the root in terms of the audio authorum parting rule, were followed. So if they weren't, the court would not concern itself with whether or not an offense has been committed. That's why I'm saying that the EC still, in my view, reserve the right not to just wholesale or apply a wholesale reception of all the applications. Once some, in their view, determine that some may relate to the commission of an offense, I think that all of us have a duty to ensure that we don't condone the commission of an offense. I'm not saying that any of them has been found so far to have bordered on commission of an offense. But the point is, it is still the duty of the EC to determine what errors are anticipated by CIN and therefore amenable to amendment or alteration. And for me, that is very key.
All right, thank you, sir, for your time. Yao Pong is a law lecturer at the Central University College, sharing his thoughts with us on the Progressive People's Party suit today. They have been, per the ruling, allowed to go and correct the anomalies on the nomination forms. Per what Mr. Pong tells us and his interpretation of what he heard in court today, is not a straitjacket, automatic route for Dr. Nduom to be part of the elections. Well, we've had contrary legal opinions on this matter. We'll be glad to share your thoughts, for you to also share your thoughts with us on our social media handles. So join us on TV, on Facebook, same on Twitter. You can add the hashtag #ThePulse to your comments. We'll be glad to share your thoughts with the rest of the world. Arguably the biggest story today in our courts. But